Love may lift us up where we belong, where eagles fly, but wedding planning can drag us right back down to earth. In 2012, Air Force Captain Tyler Eppes planned his dream nuptials with his bride-to-be. The destination wedding was pricey, and he tried to find ways his dearly beloved could save a few bucks. A room block simply wouldn't cut it, and Eppes pulled some strings to waive taxes on the rooms and fly his buddies in for free. And by pulling strings, I mean he forged documents and committed fraud. The wedding festivities were just the tip of the fraud iceberg, and in the blink of an eye, Captain Tyler Eppes went from saying "I do" in his vows to "I did" in his guilty plea hearing. This is Conduct Unbecoming. I'm Erin, and I'm your host. In July 2012, Captain Tyler Eppes, an Air Force Office of Special Investigations agent, began a new job as the Air Force Chief of Staff's personal security advisor. It was a competitive job placement, and Captain Eppes won out. He shared an office with his coworkers in the Pentagon, where they had communal and shared access to the desks and computers. This job required Captain Eppes to travel extensively. And this wasn't new to Captain Eppes. He had previously provided counterintelligence support to the Air Force Special Operations Command forces. Captain Eppes worked in a position of trust, and the nature of his job and his travel meant that he worked with very little oversight from his chain of command. In 2008, a few years before moving to the Pentagon position, Captain Eppes received a letter of counseling in his record. He'd been caught falsifying travel documents. His command had some administrative tools they could access to try and correct the behavior. They issued him the letter of counseling, which is just above verbal counseling. Verbal counseling might sound like "you need a haircut" or "don't defraud the Department of Defense." The letter of counseling is a slightly more formal way of describing lousy behavior. It's more formal because it's in writing. The letter of counseling has to explain what the bad behavior was and the possible consequences if the behavior continued. The airman receiving the letter of counseling signs it to indicate receipt and understanding. They also have the option of challenging the letter of counseling in an official rebuttal. From what I could find, a letter of counseling is generally regarded as a slap on the wrist and doesn't materially affect an airman's career. And I think we have a pretty good indication that this is true, because Captain Eppes still got that competitive job at the Pentagon. And Captain Eppes was on a time crunch with his new job. His wedding had to hit that sweet spot between onboarding and being entirely up to speed when people are dependent upon you. He planned to wed in Dallas, Texas in November 2012. Now, during college, our Greek life coordinators had a magic number. Anything more than 4 sisters made a hangout an official sorority event that was subject to all the rules and regulations of the Greek life office. Captain Eppes must have felt similarly because he claimed his wedding as an official Air Force function. And as an official Air Force function, he could prepare travel orders for his buddies, who he called his security team, and waive state taxes on the accommodations. And Captain Eppes knew that his wedding would take a lot of extra hands, so he also paid an enlisted airman in his office to take leave and act as his assistant. Captain Eppes was not managing the stress of wedding planning very well and lashed out at hotel staff. On November 13, 2012, he had a series of phone calls and disagreements with the hotel staff. During these disagreements, Captain Eppes threatened to remove the hotel from the approved list of hotels for government employees and to cut them off from receiving government travelers in the future. No one could remember his exact term, whether he explicitly threatened to blacklist them, but everyone agrees that Captain Eppes threatened the hotel staff. And this didn't sit well with the hotel manager, who didn't want to lose future business over a groomzilla. Perhaps the hotel staff wondered what kind of wedding could possibly be an official military function. On November 16th, the hotel manager tried to smooth things over by contacting the Air Force Office of Special Investigations, or AFOSI, and the Office of the Chief of Staff of the Air Force. They opened an investigation because this was the first they'd heard of the official Air Force function in Dallas in November. Captain Eppes' commander contacted him about what they'd heard from the hotel in Dallas, and Captain Eppes said that it was just a misunderstanding and that he would take care of it. But something tickled at the investigators and the command. They wondered whether it was possible that Captain Eppes was abusing his position of authority. Now, no one wants to work Thanksgiving, but Special Agent Armstrong really drew the short straw in 2012. He landed in Dallas just days before the holiday. On Monday, November 19th, Armstrong arrived in Dallas and spoke with the hotel staff. During these conversations, he learned Captain Eppes applied for tax-exempt status for the wedding. Armstrong collected copies of the event paperwork and emails between hotel staff and Captain Eppes. Armstrong then turned his focus to the so-called security detail that Captain Eppes secured. They provided Armstrong with their copies of the documents authorizing the detail and their travel. In discussing this kind of bizarre security team presence, the team shared that Captain Eppes mentioned an insurance claim for a burglary at his previous residence. 10 days later, on Thursday, November 29, 2012, a colleague back in the Pentagon office rifled through a desk drawer trying to find a work memo, a memorandum for record. Captain Eppes prepared the memo to explain the government travel he and some colleagues took in September. He said he remembered preparing the document and leaving it in the office before he left for his wedding. Inside the desk, this coworker found a folder labeled with the dates Captain Eppes and his colleagues were out traveling in September, a folder for the Chief of Staff of the Air Force Special Interest Itinerary for September 10th through the 11th, 2012. The coworker concluded that this must contain the memo they were looking for. They needed this memo in order to file a travel voucher for an enlisted coworker. But inside the folder, they found an itinerary for a wedding shower. Captain Eppes' wedding shower. The coworker realized there was no special interest travel for the Chief of Staff of the Air Force. This was Captain Eppes' personal event. The coworker scanned and emailed it to the AFOSI supervisors. On Thursday, December 6th, AFOSI formally searched the desk Captain Eppes shared at the Pentagon. Investigators seized his computer and a receipt for a camera. Technology in hand, investigators began searching through Captain Eppes' work email accounts. But a desk drawer and a work computer aren't the only places that evidence could exist. Back in Episode 4, the Darnell case, I talked about how base commanders can authorize a search of any building on base, including a residence. But no one lives at the Pentagon. So searching Eppes' home required getting a warrant from someone that had the actual authority to issue one. Captain Eppes lived in Washington, D.C. itself. So Armstrong sought a warrant so investigators could search Eppes' home, computer hardware, computer software, and digital media for evidence of fraud against the government. Armstrong swore to the facts contained in an affidavit and requested authorization of a search warrant before a District of Columbia Superior Court judge on December 7th. The Superior Court judge found probable cause for the search. That is, the judge believed a search of Eppes' home would reveal evidence of a crime. Warrant in hand, AFOSI searched the Eppes home that same day, December 7th. They found blank prescription forms, empty prescription medication boxes, receipts and documents from 2 bags in the living room, USB drives, hard drives, and a personal laptop. Investigators began searching through these electronics for additional evidence. With this mounting pile of evidence, AFOSI agents finally had their first interview with Captain Eppes on Saturday, December 8th. This was the first day Captain Eppes was back from his honeymoon. In fact, he went straight from the airport to the interview. And I wonder how familiar the interviewing agents were with Captain Eppes. They all worked for AFOSI, and from what I can tell, they only maintain a staff of about 3,000 people. Agents asked for consent to search through the bags Eppes had with him, which he gave. Within the bags, they found travel orders on official letterhead, additional prescription forms, a laptop, a BlackBerry, SIM cards, an iPad, an iPhone, and medications. I suspect, given the time frame and the DoD's love of BlackBerries, that the BlackBerry was his work phone and the iPhone was his personal phone. When agents asked for consent to search the electronics found in the bags, Captain Eppes declined. Undeterred, agents requested and received verbal search authorization from a military magistrate. In order to get that verbal search authorization, agents called the magistrate judge, described the crimes they believed Eppes committed, and the evidence they thought they'd find on the electronic devices. The magistrate granted verbal search authorization on the 8th and wrote it out in writ form on Sunday, December 9th. In addition to all of the evidence seized in these searches, FOC had access to other reports and submissions made to government programs. They combed through the travel claims Captain Eppes submitted to the Defense Travel System, or DTS. They pored over government travel card records and reviewed Captain Eppes' financial, insurance, and medical records. Captain Eppes frequently traveled for his work. Between 2009 and December 2012, he'd submitted 60 separate travel vouchers. 51 of them contained false information. 5 were utterly fraudulent. The 5 completely fraudulent trips were trips that Captain Eppes charged the government for, but trips that didn't exist. The United States lost $80,000 through this fraud. A review of his insurance records also revealed evidence of fraud. Specifically, he claimed his vehicle was damaged during a permanent change of station move. He then filed false claims in order to recoup money for damages that didn't actually occur. Then, Captain Eppes filed a claim with USAA, a commercial insurance company that serves military members and their families. He filed for stolen personal property from a fake residential burglary. These claims to USAA were for a total of $91,000. And he'd worked up all kinds of paperwork to support his claimed losses. And circling back to the prescription pad and the miscellaneous pills, there was no corresponding entry into Captain Eppes' medical records. As it turns out, people being investigated for abuse of their position and government fraud don't get to continue showing up for work to the Pentagon each morning. Captain Eppes was relocated to a small office in Chapel 1 at Joint Base Andrews in Maryland. Chapel 1 is one of 2 buildings where religious services are held on Joint Base Andrews. Not quite the usual post for an FOC special agent. His command stripped Captain Eppes of his ability to carry a weapon as an FOC agent and issued a no-contact order to keep him walled off from the investigation into his conduct. On February 5, 2013, Special Agent Cooper requested authorization to search Captain Eppes, the Chapel 1 office, his bags, and his personal vehicle. A military magistrate granted the authorization, but the issued warrant did not expressly include Eppes' bags. Special Agent Cooper and his colleagues searched Captain Eppes, his temporary office, and his vehicle. On Captain Eppes' person, they recovered a watch they believed to be evidence of insurance fraud. Inside the temporary office of the chapel, they found leave authorizations, bank statements, a permanent duty travel voucher, blank Chief of Staff of the Air Force letterhead, and various other documents. In his car, they found a jewelry invoice, pharmacy receipts, and documents falling into the broad category as evidencing false claims against the United States. Agents then turned their focus to 2 bags Captain Eppes had with him. They'd listed bags specifically in the search warrant affidavit, which kind of amazes me. This man was put in professional timeout in the back offices of a chapel in Maryland and ordered not to contact his colleagues. There was no meaningful work he could do, yet he still brought 2 bags with him to the office, and investigators thought to include those bags in the search warrant affidavit. Agents searched the bags and found 1 Marriott room rate discount authorization form, altered in order to have a blank date, an 18-page merchandise inventory sheet, a 10-page USAA valuable personal property insurance document, 11 airline tickets and travel-related documents, 3 blank USAA checks, 3 blank Chief of Staff of the Air Force letterhead documents, 1 Cole Haan receipt, 1 City Direct statement, 1 ATM card with Africa, Russia written on it, and an envelope from the Foundry Lofts residential building. Cooper then executed an additional search warrant at the Eppes home. There, they recovered documents related to the sale of jewelry and watches, insurance documents, more airline tickets, more receipts, and cameras. As it turns out, Captain Eppes had stolen 2 government cameras valued at approximately $5,000 each. He sold one to a college friend for just over $1,000. But we still haven't reached the depths. Agents uncovered a prescription drug conspiracy. At some point before the wedding, Captain Eppes contacted a friend, another airman, who was traveling through Africa for the Air Force. Captain Eppes shared that he was anxious about the upcoming mega wedding and needed something to take the edge off. Captain Eppes provided forged prescriptions to his friend and asked him to stop by a pharmacy to pick up Valium and Xanax. Allegedly, the friend believed Captain Eppes was trustworthy because he was a special agent. The friend filled the prescriptions, brought the drugs aboard a military aircraft back to the United States, and then mailed them to Captain Eppes. I can't find the details of how this scheme came to light, but the friend was court-martialed for conspiracy to obtain controlled substances and possession, transportation, and distribution of a controlled substance. At the court-martial, defense counsel won a motion to suppress the friend's interview with investigators, and, as a result, charges were dismissed. His command was displeased with this outcome and initiated a board of inquiry and discharge proceedings. The friend was discharged from the Air Force on July 14, 2015, with an other-than-honorable characterization of service. He'd served in the Air Force for 19 years. The friend appealed, asking a discharge review board to upgrade his characterization of service to honorable. In his appeal, he even included a letter from his co-conspirator, Tyler Eppes. His request was denied in a 4-1 vote. This feels like the correct result, because as challenging as TRICARE can be to navigate, it's unreasonable to think that Captain Eppes couldn't fill a valid prescription himself. His friend took a risk, gambling with a 19-year career, and it backfired. 2 years after the fraud was first uncovered, Captain Eppes was court-martialed in March 2015. The defense team moved to suppress evidence obtained during the various searches. The court-martial judge denied the motion to suppress and issued a 29-page ruling on the evidence, which laid out the comprehensive findings of fact and conclusions of law. All of the evidence obtained in the searches came in, and as a result, Captain Eppes made a guilty plea. Captain Eppes pled guilty to conspiracy, false official statement, theft of military and non-military property, fraud against the United States government, and conduct unbecoming an officer and a gentleman. This was before they took out the gendered language. And yes, all of the conduct I've told you about so far is unbecoming an officer and a gentleman. But this conduct unbecoming specification related to behavior I haven't even told you about yet. Captain Eppes was returning from deployment in Africa, and he solicited the help of a buddy stationed in Belgium. He needed his buddy to transfer money in small increments back to Captain Eppes when he got home. And legal beagles, I cannot find the origin of this money. This is absolutely a case where the fact section of the appellate opinions could have been more clear. Transferring an amount like that necessitates reporting and probably taxes. His Belgium buddy moved the money to Captain Eppes in increments under $10,000 over the course of 2 years in order to avoid federal reporting requirements. Consistent with his guilty plea, the military judge sentenced Captain Eppes to a dismissal, a $64,000 fine, forfeiture of all pay and allowances, and 10 years of confinement. To uphold their end of the deal, the government dropped the additional specifications for making false official statements and agreed not to prove up allegations that Captain Eppes stole approximately $65,000 in currency while deployed. These allegations are what made me really question the origin of the $50,000 in wire transfers. if Captain Eppes failed to pay the $64,000 fine the judge ordered, his confinement would be extended by an additional 3 years. But because his base sentence of 10 years is not over 10 years, Captain Eppes got to avoid Fort Leavenworth and was imprisoned at the Naval Consolidated Brig in Charleston, South Carolina. Before heading to the Naval Consolidated Brig in Charleston, Tyler Eppes tried to persuade the convening authority to waive the forfeitures because it might leave his new dependent wife without adequate support. The convening authority denied the request. If Tyler Eppes was genuinely concerned about his wife's financial situation, he could have planned a less extravagant wedding, a shorter honeymoon, kicked his prescription pill habit, and, not committed financial crimes against the United States government. The Air Force Office of Special Investigations exists to defend the nation, pursue justice, protect the Department of the Air Force, and find the truth. So the safety brief today is just a reminder that if you and all of your colleagues get paid to find the truth, just assume you won't get away with fraud. On appeal, Tyler Eppes raised 7 issues, including that his sentence was inappropriately severe. Today, I'll focus on the evidence obtained during the various searches. Usually, a guilty plea waives the ability to raise suppression issues on appeal. However, defense counsel here expressly conditioned the plea on preserving the right to raise the suppression issue on appeal. The appellate courts had to evaluate the suppression motion decision under an abuse of discretion standard. They had to determine whether the court-martial judge abused their discretion in their ruling, whether the decision was clearly erroneous. And the appellate court has to consider the evidence in the light most favorable to the prevailing party. Here, that would be the government because they won on the suppression motion and all of the evidence came in. The Air Force Court of Criminal Appeals disposed of several issues Tyler Eppes raised, and the Court of Appeals for the Armed Forces, or CAF, handled the December 7, 2012 search of the Eppes residence and the February 5, 2013 search of the bags in his Chapel 1 office. In his first appeal to the Air Force Court of Criminal Appeals, Eppes argued that the search warrant issued by the D.C. Superior Court lacked particularity for the things to be seized. He specifically cited the blank prescription drug forms and empty prescription medication boxes as examples of evidence seized that didn't fall within the bounds of the search warrant. At his court-martial, the military judge had concluded that even if those weren't within the bounds of the search warrant, they'd fallen under the plain view doctrine. Law enforcement can seize items that are in plain view if law enforcement is where they're allowed to be, and they have probable cause to believe the seized items are evidence of a crime. I find it most helpful to think of it in terms of things that are clearly illegal to possess. For instance, if law enforcement entered a home with a warrant authorizing them to search for and seize electronic devices, and on the coffee table they see a tray with lines of white powder and a straw, they're allowed to seize the supposed cocaine. They don't have to go back and get a separate warrant authorizing them to search for and seize drugs. In his appeal to CAF, his team raised the issue of probable cause surrounding his personal computer. In order to comply with the Fourth Amendment, police must have probable cause to believe that the place or thing searched have evidence of a crime. CAF described probable cause as a flexible common sense standard, not a hyper-technical standard. There has to be a substantial basis for finding probable cause, and if the search authority has a substantial basis to find probable cause, a court-martial military judge does not abuse their discretion in denying a motion to suppress. The affidavit submitted with the December 12th warrant request laid out that Tyler Eppes provided false documents by email to the hotel staff that was hosting his personal event, that he falsely certified that his wedding guests were on official business, that he lied about the event's tax-exempt status, and that he produced fraudulent travel orders for his wedding shower. The affidavit also included information that Captain Eppes had previously defrauded the government through falsified travel documents. And CAF took this opportunity to point out the obvious. Tyler Eppes emailed his false documents to the hotel, and he would have used a computer or other digital device to send that email. And given the sheer number of electronic devices they uncovered throughout their searches, the work computer, the USB drives, hard drives, a personal laptop at the home, another laptop he'd taken on his honeymoon, a BlackBerry, various SIM cards, an iPad, an iPhone, Tyler Eppes had to falsify those documents on something. There had to be a digital copy of them somewhere. Tyler Eppes, as a law enforcement official, may have intentionally stored them on his personal devices instead of on his government devices. It was reasonable for the issuing judge to conclude that evidence of a crime existed on electronic devices owned or controlled by Tyler Eppes. And that would include his personal laptop. In a footnote, CAF left a little Easter egg for the astute reader and wanted to be clear. They didn't mean to suggest that service members are likely to store criminal evidence on their home computers, but that this was a specific risk with Tyler Eppes. Shifting to the February 5, 2013 search of the Chapel 1 office. On appeal, Tyler Eppes argued that the evidence discovered in his bags should have been suppressed. The bags were not explicitly included in the search warrant, though they were specifically included in the request. The court attributed this discrepancy between the request and the warrant to a scrivener's error, an unintentional drafting error. But the Fourth Amendment requires that a search warrant list the place to be searched with particularity, and the warrant here didn't. Therefore, CAF concluded, the bags were beyond the scope of the search authorization. To refresh your memory, these bags contained the altered Marriott room rate discount authorization form, the insurance inventory sheets, 11 airline tickets and travel documents, misappropriated Chief of Staff of the Air Force letterhead, and a work-related ATM card. If the court found that the court-martial judge abused his discretion in admitting this evidence, that evidence was gone. And that evidence sparked further investigation, which could lead to other evidence being suppressed because it was fruit of the poisonous tree. However, CAF decided that agents would have inevitably searched the bag and discovered the contents. If agents discovered the scrivener's error, they would have applied for and received authorization to search the bags. Further, agents were already actively pursuing leads that would have led them to the same evidence. They were already aware that Tyler Eppes committed travel and prescription fraud and were investigating whether he also committed insurance fraud. And this scenario was different than the Darnell case. Law enforcement hadn't gone wild and tried to get away with it. They swore an affidavit laying out the nexus between the bags and the suspected crimes. They just didn't proofread the warrant. A concurring opinion pointed out that the warrant did permit agents to search Tyler Eppes and the area immediately around him. The concurrent seemed to relish pointing out that Eppes worked out of a closet-sized office, and the bags couldn't be anywhere except immediately around him. The concurrence agreed with the result, but I wanted to mention it specifically so I could recite my new favorite legal quote. Are you ready? Humans are not koalas or kangaroos, and the human body thus does not have natural pockets or pouches in which to store either watch and jewelry collections or documents related to insurance and travel fraud. Having lost his appeal at CAF, Tyler Eppes appealed to the Supreme Court of the United States, where he promptly moved to proceed in forma pauperis, or, without the Latin, without a lawyer. How I wish I could bottle this level of confidence. His writ petition focused on two issues raised by a partially concurring, partially dissenting CAF opinion, focused on the February 5th search of the bags in the Chapel 1 closet office. He was denied cert. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com. If you want additional episode details and behind-the-scenes tidbits, join me on Instagram @conductunbecoming. Before I sign off on this episode, I want to wish two special lovebirds in my life the most magical wedding weekend. I chose this case because it seemed like fortuitous timing when I ran across the CAF opinion. I am confident your wedding, honeymoon, and marriage will be far less dramatic. We can't wait to celebrate your love and to get out on the dance floor. Join me next time and learn how not to celebrate the 4th of July. Until then, take care. Conduct Unbecoming is a podcast where I talk about interesting crimes and cases involving U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, endorsed, or authorized by the Department of Defense.